Hello, and welcome to the Law School Toolbox podcast. Today we are talking about how to find success during your 1L Moot Court experience. Your Law School Toolbox hosts are Alison Monahan and Lee Burgess. That's me. We're here to demystify the law school and early legal career experience so you'll be the best law student and lawyer you can be. We're the co-creators of the Law School Toolbox, the Bar Exam Toolbox, the Catapult Conference, and the Trebuchet Legal Careers site. Alison also runs the Girls Guide to Law School. If you enjoy the show, please leave us a review on iTunes. And if you have any questions, don't hesitate to reach out to us. You can reach us via the contact form on lawschooltoolbox.com, and we'd love to hear from you. And with that, let's get started.
Welcome back. Today we're going to be talking about doing moot court and rocking your first semester oral argument, which is something that most 1Ls are going to end up doing second semester of your first year. But if you've already finished moot court, this advice might still be helpful if you're going to take part in some other type of advocacy competition. So Lee, let's start off. What actually is moot court?
So moot court is something that I think all law schools have in one form or another, and it's basically to give 1Ls exposure to drafting appellate arguments and then actually standing up in front of judges and doing an appellate argument. Some schools have a written component that's part of the course, and so you actually have to write an appellate brief. Sometimes you only will write part of it, sometimes you'll write the entire thing, but you usually just write one side. So you're either representing either the plaintiff or the defendant, or if it's criminal, possibly the government or the defendant. And then, sometimes you only are responsible for writing even one issue in the brief. So there are so many different ways to do this, but there's usually a written component and then the oral component. Sometimes schools grade on moot court. My entire moot court experience was pass-fail, but that was partly because it was run by a student-run moot court council with faculty advisors, and so I guess they didn't want to give them the power to grade us. I'm not really sure, but a lot of schools have at least either part or all of it be graded. So it really depends. It's usually somehow linked to your law school legal writing program.
Yeah, I mean, that was the way that it was for us. We got, I think, partners teamed up, and we had to team up on different issues in an appellate brief to write one side of it. And then I guess we both had to argue. I mean, we must have both argued. So it was like teams of two, and different people were arguing each issue, as I recall.
And we had to argue one side, and then we argued against like another team that had all briefed the other side.
Right, exactly.
Yeah.
But I think it was split, so it was like two separate issues.
Oh,
so
okay.
you were like, you and your teammate were jointly responsible for one side of the argument, but it was like two separate, sort of distinct arguments, as I recall.
And then did you guys have real judges or alumni come and become judges for the appellate arguments?
Yeah, it was definitely like a team of people you had never seen before who were judging you. I don't remember exactly what they were, but they were definitely practicing lawyers, and they were definitely pretty scary, as I recall.
I know. I think some of the alumni took it pretty seriously. They were.
Oh yeah, I mean, I think we might have even had like a sitting judge on the panel and like partners in law firms. I mean, it was definitely, these are people who are pretty intimidating, as I recall.
Yeah, and I think just anytime that you stand in front of a panel of anybody and speak to them is intimidating, let alone if they are judges or practicing lawyers. I mean, I think if you've never seen a real appellate argument, it is definitely set up to be intimidating.
Right, and it's not that, it's this sort of thing where like they're not just letting you kind of like give your little speech. I think sometimes people think like, oh, I'm just going to go in and I'm going to prepare my argument and I'm going to like read my argument, but that's not really the way that this works, unfortunately.
Yeah, I think that's one of the things that makes, moot court so intimidating for law students. And then, of course, what makes oral advocacy at the appellate level such a craft is you do have to really understand that although you might go in there with all these things that you want to say, the dynamic is you are just going to be interrupted and peppered with questions. And so you have no control over really the content of the argument, which is what really makes it a challenge.
Right. And I think that's why it's challenging to prepare for, because you sort of have to be ready to jump off in all these different directions. And, sometimes people get really intimidated if they're asked if they're asked questions in an oral argument, but really, you know, and this is the same in real life, like that's an opportunity for you to actually convince the judges of your position. I mean, you know, I think we've all read even stories of like Supreme Court arguments where people, you know, the judges are like, I don't actually know for sure which way I come down on this. Like the briefs are all really good. Mm-hmm. And if I'm asking questions, it's because I actually want an answer. I'm not doing it to be difficult. Right. And so, you know, I think approaching your moot court argument in that spirit of, it's not that they're trying to throw you off your game by asking you these questions. It's thinking about how can you prepare, you know, how can you prepare your argument basically so that you're able to go off on these tangents and respond when someone actually has a question.
Yeah, you really have to have a mastery of the material and a comfort level with the material that you can discuss it in an intelligent way.
Yeah, and I think a lot of that is like, you know, thinking about how you're going to prepare. Like if you think that you're preparing a speech, that's not going to be as effective as thinking about other ways to, you know, thinking about like, well, what are the key questions? You know, what are the gray areas in the brief? Like put yourself in the position of the judges. Like what would I ask myself? What would I ask this person about if I was a judge? You know, you want to be prepared to respond to all of that.
No, it's very true. Do you remember, wasn't it a few years back, you and I went to an event hosted by Above the Law where David Latt was interviewing folks who were some of the attorneys preparing for the arguments at the U.S. Supreme Court on Proposition 8?
Yeah, that was interesting.
That was interesting because as we talk about this, I'm remembering them talking about prepping for those oral arguments. And, you know, these attorneys who are, you know, well seasoned and have argued at the Supreme Court over and over again, which, I mean, if talk about being at the top of your craft, if you're somebody that they bring in to just make arguments at the Supreme Court.
I know I saw a funny thing on that note about, I guess Apple recently hired Ted Olson to go against this subpoena from the FBI. Mm-hmm. And they put out a press release, something to the effect of like, we're prepared to go to the Supreme Court. And all the lawyers are like, we know that. You hired Ted Olson.
Exactly.
Like, there's no mystery here. We know where this is heading.
But I thought what was so interesting when we were at this talk, and this talk was so legal geek like oriented. It was so funny. I mean, everyone in there, it was like we were all using legal speak and con law terminology, and I was thinking that if anyone in there wasn't a lawyer in law school, you would have had no idea what was
and been bored out of your mind.
Yeah, but I thought it was interesting that even these attorneys who do this for a living, who are known to be at the top of their craft, they do such significant preparation of these mock arguments where they have other of the attorneys that work on the project peppering them with questions, because even at that level, it is very hard to manage an argument like this.
Oh, yeah. And there's actually fascinating. I got a tour of Georgetown Law School one time, and they actually have an exact replica of the Supreme Court chambers. Wow. And they have one. And so they're like, for basically every major Supreme Court case, like we get phone calls, and it's basically like whoever calls first gets to use this, whichever side calls first gets to use this to prep. And it's literally like the exact, you know, the furniture is the same, wow. The carpet is the same, like everything is the same. So, and that's where they do their prep work. So it's like when they walk in there, it's not like, oh, I've never done this before. And I think that's the feeling that ideally students need to go in with too, is like, yeah, this is the first time you're doing an oral argument, but it's sort of like taking an exam. You don't want it to be the first time you've ever thought about how to do this.
Exactly.
And practiced it.
And realize, I think, that the fact that it is set up to be intimidating. I mean, I know that every time I've stood in an appellate courtroom, and I have not argued at the appellate level at all, but I've watched other people do it. These courtrooms are all set up to be very intimidating. Usually the justices are like raised above you somehow, right, and like are looking down at you. Yeah. I know the Ninth Circuit is that way as well. And, you know, it's even in my law school, I mean, we did it in one of the lecture halls, and the judges, you know, we stood at the podium like where a professor would stand, and then the judges sat up in the seats so they could look down at us. You know, I mean,
yeah, it's very hierarchical.
It is very, very hierarchical. Have you been to the Ninth Circuit building in San Francisco?
I'm not sure I've ever been in there,
bank,
actually.
It's like either, I can't remember if it's an old bank or there's an old Federal Reserve. There's like a vault in it. There's still like an old vault. But it's all marble, and so everything's very booming.
Yeah.
And it's...
I've been to the First Circuit arguments a lot when I was clerking in Boston. We would always go to the First Circuit arguments. But yeah, I mean, there's like a very particular courtroom architecture, and it's set up that way for a reason. Mm-hmm. And, you know, I think particularly for people who are reluctant public speakers, this can be really intimidating.
Yeah. You know, some of my friends really had a lot of nerves around this, even in law school, and were like throwing up in the bathroom before arguments. If you are nervous about public speaking, I think it's something you want to think through, just how you're going to get through this experience.
Yeah. And I mean, I think practicing it, even if some cases, like if you know what classroom it's going to be in or, you know, what room it's going to be in, you might even be able to sort of sneak in there after hours and like have some friends like pepper you with questions and that kind of thing. Mm-hmm. Anything you can do to just kind of get more comfortable in the setting. But I think also recognizing that like this is a stressful experience for everybody.
Yeah.
Almost no one's going to walk in there and be like, oh yeah, I totally got this. Like I know more about this than like the people who are asking me questions. It's just not the way it works.
Yeah. No, I think that's really true.
I remember I did my oral argument with like the worst case of laryngitis ever. I could literally barely speak.
Oh, God.
Which was actually probably good in a way because it kind of took the pressure off of like I have to be perfect to just like I really hope that I can drink enough honey tea for my voice to last for the half hour that I'm going to be in there because what am I going to do? I might fail the class if I don't if I literally can't speak. Mm-hmm. In the end, somehow I got like the best oral argument in the group award, mm-hmm. but I don't know how that happened. I think it was like a sympathy vote.
So I think the nice thing that most schools do, I think, especially for folks who really are intimidated by this process, is oftentimes moot court, at least part of it, is pass-fail. I hear that pretty consistently from students.
Yeah. I mean, you're doing it mostly for the experience. Yeah. This is not something where it's like, it's going to determine the course of your law school future. This is just something that you have to do for the experience. And like, maybe you like it, maybe you don't. But I think treating it as, this is an experience. I'm going to get the most out of it as I can, but I'm not going to worry so much about like, did I say something wrong or whatever?
Right.
Is probably the best way to approach it.
I think that's true. I think the other challenge for students is with the time management piece of it. Because if you like this sort of work, it can become a huge time suck. And usually this happens not too far out from final exams. And so mm-hmm. oftentimes I have to really tell students that as much as you're having fun working on moot court, you have to cap the amount of time that you spend on it, because if it is pass-fail, you cannot spend 40 hours the week before your oral argument preparing in lieu of studying for final exams, because in the grand scheme of things, it's not going to be reflected on your transcript.
Right, exactly. It's like, yeah, it's nice to be able to put like, oh, you got the award for whatever, but it doesn't actually, if you flunk all of your other classes as a result, it's not going to end up paying off.
Yeah. That being said, I would not ignore it because you never know who the judges may be. Turned out that one of the judges on my panel was on my callback interview at my big firm job. And nice. We were standing in the elevator and she's like, I know you and I don't know how I know you. And it took a while for us to come up with the fact that she had been on my panel. And so it was a really good thing that I had been well prepared, that mm-hmm. I also won the oral argument award. And because I think it helped in that interview, because she definitely remembered me enough that, a year later, it was still like in her mind who I was. And if she'd had a negative association with me, I'm sure that she would have remembered that too.
Right. Yeah. If you'd been the girl who stood up and went like, well, yeah, I don't really know. That's like a great question. Right. But I didn't like really research that. So yeah. Whoops. Yeah. This is the beginning of your professional reputation. And you don't want to get this reputation for being a slacker, for being unprofessional, for being unprepared. But that being said, as with anything else, it has to be done within reason. And again, I think this is the 80-20 rule. Like, yeah, you could spend 40 hours the week before researching like some really obscure piece of the law. But, think about the people who are reading your briefs. Like, best case scenario, they kind of are familiar with the problem. They've read the briefs and they're ready to go. Mm-hmm. That's your best case. Like, they might not have even looked at them. They're not delving into like these obscure details that someone who's been working on this problem for months might know about.
Right.
No, and they're not trying to trip you up.
No, they're not like, usually they're not trying to be mean. They're just trying to, help you with the exercise.
But they might not be mean.
That's true. All right. So what about just the written part, if you have a written component? What tips do we have to kind of help people be successful in writing this, maybe their first persuasive brief that they've ever written?
Yeah, well, I think we've got some good content on the website from one of our tutors who's taught legal writing for a long time about how to make a brief persuasive and, how to use things like the facts persuasively. And you might think, oh, well, the facts are objective, but that's not really true. You're trying to get sort of your view of the facts to be the view that's adopted by the court, who are basically, the people sitting in front of you. So, I think we can link to those articles and people can take a look at that. But, things about like basic organization, as we said, these are people who are reading your brief for the first time and they're going to ask you questions. So you can think about in the organization, like, what do you want them to focus on? I think that's always a really key. What if you had to, great trial lawyers are like this, they can stand up and they can take this really complicated case and they can say, Your Honor, ultimately, this comes down to 3 factors, and those factors are blah-de-blah, blah-de-blah, blah-de-blah. That's the sort of mindset you want to be in when you're writing your brief about, like, well, what are my key takeaways? What are the really important things I want them to focus on? What are my strongest arguments? And structure the brief so that those are really the focus and those are up front.
Yeah, I like to think about it as really telling your version of the story. You are taking the reader on a journey, whether it's the judge or whoever you're writing to. And the more logical and organized you can make that journey, that's when it becomes really powerful. I always would find it interesting when you read really well-crafted judicial opinions where they really can take you step by step.
And it seems inevitable.
Yes.
Conclusion. You're like, of course they had to come out
this
way.
And, the recently departed Scalia, I think, is one of those judges or justices who could write kind of these very logical arguments, and then you get to the end and I would just be like, no, I don't agree with you. Even if I agreed with like 3 things you said, I still don't agree with you. But thank you for taking me on that journey. But, I do think that ability to boil things down and go step by step is part of the craft, whether or not you want to be a litigator. Even if you're a transactional lawyer and you're writing, demand letters and things like that, again, being able to organize your work in a way that it just takes someone down a logical path is a really powerful skill to learn.
Absolutely. And it doesn't mean you can just ignore counter arguments. In any situation, you're going to have things that do not support your case, and you need to deal with those and deal with them directly. But, you probably don't want to start your brief by like countering some of your opponent's best point.
Right. Exactly.
That needs to be on like page 5 after everyone's already sort of skimming. You're like, oh yeah, right. They did address that. Okay. I'll make a note to ask about that.
Mm-hmm. And if you're struggling on where to find these organization ideas, I think it's always a good idea to look to some of the legal precedent that you're citing to. Oftentimes, whatever analysis you're doing is not something that's been completely, never done before. You don't need to reinvent the wheel. Sometimes your case might be slightly different than something that has happened before, but you can take cues from opinions that you think make a lot of sense and lay out a similar argument. I think that's a really powerful way to learn how to, craft your organization so it is easier for the reader to follow.
Right. And I think also if people have never seen an appellate brief before, hopefully your legal writing or moot court instructor has given you something to look at as a sample. But if not, you can actually pull these briefs. Everything that gets filed in a federal court or probably a state court, they're all accessible. These are public documents. So in the federal court, you might have to go and pay a couple of dollars to Pacer, which is, 10 cents a page or something, I think. But, pull a couple of appellate briefs in famous cases and just look at them. Mm-hmm. I think that can be a great way to sort of get the feel of like what it is that you're trying to do here.
Yeah, I think that's really true. And understand the tone of these persuasive briefs, because I think that is the big shift when you write persuasively, is just to feel comfortable with that tone.
Yeah, absolutely. And in terms of the legal research, get whatever help you can. If you're allowed to talk with your research librarians, that's a great place to go. If you're allowed to talk with your professor in office hours, or, if it's student run, a student advisor, like these are the people who are there to help you, and you shouldn't be struggling with this stuff like totally on your own. Ask them the questions and get the help that you need so that you can actually get the research done.
Mm-hmm. I think that's really true. So once you've done your writing assignment, then it's time to prepare for...
Can we touch on one more thing with the actual writing?
Oh, yes.
Which is if you have to write with a partner, That is, A, you want to try to get a partner that you actually trust, and B, this is sort of thing where you need a process and you need like check-in points. I mean, I remember my Moot Court partner, who was a great friend of mine. I don't know how he even managed to do this, but literally the night before, like sometime at 3 a.m, before these briefs were due, he somehow managed to, like, I can't remember what it was, like either delete all the periods in the brief or like change some word by like doing a like find and replace that made no sense, and it changed like 100 words in the brief randomly. I mean, it was one of those things where you're like, you did what? Like, why were you doing this at 3 a.m?
Yeah. Oh my gosh.
And in this case, like, luckily I actually had a copy of his like prior version that we could pull from. But, you want to think about things like, are you going to be storing stuff in Dropbox? Like, how are you going to be trading drafts? This sort of stuff. Like, always, particularly if you have another person involved, like, make sure you have backup copies of things. You might want to every day save a new version with a new name just in case, because you never know what's going to happen.
Yeah, and sometimes technology solutions can not be as fabulous as you think they are. I know you and I have done collaborative writing on using Google Docs, and it became a nightmare at some point.
Oh God, it's horrible.
It was horrible. So, you can explore that as a tool, but I wouldn't recommend it. I think we abandoned that and just went to, drafts of versions of Word documents.
Yeah, and I think the thing is, like, you just have to build in time at the end when you're going to be stressed out and you're going to be pressured to actually do things that seem simple, like combine your documents together. But it's like, well, what if somehow someone's using a different size font, stuff like this. Like, you can't just count on sort of like clicking your fingers at the last second and turning this stuff in. It's got to be, I would suggest like even like a day before, like you set a final deadline for writing with your partner. And at that point, you're only doing things like checking citations and making sure they're correct and, doing those final edits and not trying to like combine everything together and get it to be perfect.
Yeah, and citations, I think, are a big one. If you need to include citations, which I'm sure you do, those take time to double check if you have not learned that yet. So
take a lot of time.
A lot of time. And that is also not something to leave until the last minute. There are a lot of different things that you can do to make that easier on yourself. You can actually take the cases that you're going to use and then take your blue book and, just create a cheat sheet where you basically have the full citation of the case and what the short citation would be, when you're fresh and you're not so tired. So you can pull from that, even copy and paste it into some things as necessary. But you've got to go through and double check that stuff, because if your citations are a mess or your quotes are incorrect, that can really, really screw with your grade, but it can also make you look incredibly unprofessional.
Yeah, you don't want to leave the impression that you did not like dot your I's and cross your T's.
No, that going back to like working on your professional reputation, that is not the reputation you want to have.
Right, because at that point, you're probably going to get a very aggressive question as your first question.
Yeah.
So let's move on to oral argument.
Okay. So we've talked a little bit about different ways to prepare, but one of the tips that was given to me by some attorneys who had done a lot of real oral arguments, not just moot court oral arguments, was to prepare using flashcards. And so once you've done your written brief and you kind of have your major points, like Alison was saying, you have your best arguments, that you kind of put them all in flashcards, maybe including some of the counter arguments to respond to the other side. And one of the things that I found difficult about preparing for an oral argument was the idea that you had to be able to talk in a not linear fashion. You had to be off the cuff for a lot of this stuff. So by having it on flashcards, you could shuffle the flashcards and then, pull up kind of these different topics and get used to talking about them in any order. And I felt like that really helped me be comfortable with the ad hoc nature of the argument. And so, I wasn't so caught off guard when something weird was presented to me, or it's not weird, but somebody off the cuff or some different direction was presented to me. Did you do something like that to prepare, or how did you prepare?
To be honest, I'm not sure I prepared that thoroughly. I mean, I think that sounds like a fantastic idea, and I think it would be extremely effective. I think for me, I just basically had sort of a, 1-page sheet in front of me with kind of the major points that I thought were likely to come up. And I just kind of went with it. Yeah. I'm not sure I really practiced that much. I think I went in, and I think the flip side of this is it's not you want to go in totally unprepared to say something as well, because there is the possibility that they will let you talk for a minute or two.
Right.
So, I think for me, like I kind of prepared the first 2 minutes of what I thought I might be able to get out. And maybe I got 30 seconds of it out before they started being like, okay, great. Well, we want to talk to you about this.
Yeah.
I'm like a pretty good speaker on my feet. So I think I just kind of, winged it basically.
Yeah. I think I had a 1-page sheet of kind of my main bullet points that I wanted to get through. And so every time I had a break and got a chance to go back to my own speech, I kind of could start on different points. You typically don't get everything out, but at least you have a place to go back to. I do think that that's a really good point.
Right, and I think that's key. It's this weird combination of things that you want to be sure that you basically get on the record and that you would prefer to talk about, but also really trying to respond to the questions that you get in a meaningful way. I mean, sometimes what you see students, but also like real lawyers in oral argument do is kind of what politicians like to do, where they answer a question which is not actually the one that they were asked.
No, that never happens.
So, that is not really typically effective at an appellate argument because, as we spoke about earlier, basically they're asking these questions because they actually really want an answer. And so if you refuse to provide that answer, it's likely not going to end up in your favor in the end.
Yeah, I agree. What about practicing in the mirror or even recording yourself? A lot of people hate doing this stuff. I don't personally enjoy watching myself on video.
I don't think anyone enjoys it.
No.
But that's sort of the point.
Right.
Just accept that you're probably not going to like it and you're going to look worse and be harsher on yourself than anyone else would be on you. But there are things that you can, typically if this is something that's very new for people, there are things that, you probably need to correct. So things to look at are like, what are you doing with your hands? Are your hands distracting? Like, are you making like crazy facial expressions or gestures? Where are you looking?
Right.
If someone has asked you a question, and this can be tricky too, when you have a panel, you want to be looking back to the person that asked the question in large part, but not also ignoring everyone else on the panel. So there's this art to sort of making the person that you're speaking to feel like you're talking to them, but also not making other people feel excluded. Mm-hmm. These are things like you can record or you can just have people give you feedback on it. I mean, I think recording yourself in general is fantastic and also very painful.
It is. I mean, if we went back and listened to our very, very first online webinars and courses that we did 4 years ago for this this company.
I mean, I remember sort of thinking like, that was like really weird. I can't believe I'm sitting and talking to a computer in a room by myself. Now it just seems normal.
I know. But when I have listened to some of that older stuff, whether I come across it, in combing through materials or things like that, sometimes I listen to it and go, wow, we've come a long way. Because when you do listen to yourself, when you do practice over and over again, you become much more comfortable. If we'd started this podcast years ago, I don't think it would have been as entertaining.
Right. Well, I mean, even, the earlier episodes are probably a little more forced.
Mm-hmm.
But, there are things you can't do anything about. I mean, we sometimes get comments like, people hate our voice. And it's like, well, sorry, that's my voice.
Exactly. I can't say that about myself. Thanks. Thanks.
But, I mean, I think there are things, and I think, again, this is often a particular issue for women. Sometimes people have, for example, like very high-pitched voices. And can you do something about that? Can you not do something about that? I don't know. Like, should you do something about it? It's just something to be aware of. Like, if you have certain speech patterns, for example, if you say a lot or like a lot, mm-hmm. or I can sometimes switch into like California Valley Girl.
Right.
Probably that's not the place for that.
Right.
So you want to be, your voice and your tone and everything else should be like your most professional self.
Yeah.
And that's hard when people get nervous. I mean, you did speech and theater, so do you have any sort of practical tips for people, you're freaking out like minutes before walking in? What can they do to sort of calm down and like activate their voice?
I think, I'm always a big fan of going back to the breath. But I also think that one of the ways you can cope is by trying to make it a little bit less about yourself and feel like you are playing a role of this more professional persona. Mm-hmm. To me, I think, having had a background in theater and performing, that when I get dressed up in a suit to go do this sort of stuff, it really isn't me. It is this version of myself. And then it becomes a lot less anxiety inducing because it's not as personal. And I think that for me is something that's always been very helpful. And I've always thought that part of the law is interesting, that we do all dress up,
right. In England, like, they put the wigs on and stuff, which I always thought would be super cool.
Yeah. So you really are kind of outside of yourself. And I think the more that you can realize that this isn't personal, that this isn't, going down and shaking your core, I think it can be much easier to cope with the anxiety. But, preparing yourself for it, taking deep breaths, and just remembering that the worst thing that will happen is that maybe you don't win your oral argument award.
Right, you'll live.
It's just very important.
I've always liked the sort of Wonder Woman posing that is popular, particularly at women's conferences these days, where, basically you do your power pose, whether it's in the bathroom or, in the room where you're prepping. But, you literally spread your legs apart, put your hands on your hips, and sort of look like Wonder Woman. And I don't know, there are theories that it actually really, I don't know what it's doing, raising testosterone or something. But, it basically makes you, it puts you more in that mindset of yeah, I can do this. I've got this.
Yeah. And so much of it is just presenting yourself with confidence. And I think that's just about practicing law in general, no matter what you do. If lawyers smell fear, they are going to be more hostile to you. So yes. As much as you can practice being confident or faking confidence, I think it's really important.
Right. And I think for people who are maybe not so naturally extroverted, it doesn't have to be the case that your confidence is this sort of bombastic, yelling and screaming.
Right.
You can be very calm and very quiet, but also very confident. And some of the most effective litigators are the people who don't yell and scream.
Right.
If they are asked a question, they might take a deep breath, and then the answer that comes out is completely on point.
Yep, and very thoughtful and clean.
Very extremely thoughtful, and people have a lot of respect for that. So it's okay if you take the deep breath and then you answer. It doesn't have to be this all the time.
Right.
You don't have to be like the rabid dog.
Yes.
There are different ways to be comfortable.
Yeah.
But yeah, circling back to dressing the part. I mean, what are people supposed to wear here?
You wear a suit and make it a conservative suit, your interview suit. If you don't have an interview suit yet, this is a great time to go get one, which should be generally blue or black or pinstripes or fairly conservative, because you don't want it to be distracting. I think this is a bit more of a gray area for women than sometimes for men, because I think men, it's I just go buy a blue or black suit and a conservative
shirt and
tie,
put a white or blue shirt on, and you're pretty much
right.
done.
Exactly. I think for women, there can be a lot of gray area. Even around the country, there are different, levels of acceptive, quote unquote, and conservative wear. I don't think you need to ignore your own personal style, but make sure that nothing is distracting from your talk. I wouldn't wear loud or large jewelry. I wouldn't, wear a hot pink shirt under my suit. I wouldn't do things like that, because I think dressing this part is really just putting you in this role. You want to look sharp, but you don't want your outfit to be what's speaking for you.
Right. And you want to make sure you're comfortable. If something doesn't fit, or if your hair is in your face. I mean, this is even for guys. Think about the man bun if you've got long hair. Because you just don't want to be playing with your hair and doing all these things that people do when they get nervous. And same thing with distracting stuff on the podium. Probably a pink water bottle, maybe not so great.
I did have someone in my class who put a pink water bottle on the podium, and the judges laid into her about it because of how, first of all, they were you don't need a water bottle on the podium. It's 10 minutes and they're 15 minutes.
I mean, I would question whether you need anything.
Right.
But, put it behind the podium.
Right.
But wasn't there some debate recently where one of the candidates got in trouble for, got ridiculed for drinking too much water or something because it showed nerves? I don't know.
Yeah.
But, I mean, I was going to say maybe you should use a cup for your water, but then what if you knock the cup of water over?
I think you should hydrate before. And I mean, this typically is not a long experience. I think you just hydrate before and you go for it. Because all of these little things that you can have, an ink pen or a water bottle or stuff like that, those are just going to be crutches that you're going to end up playing with.
Yeah, it's like these nervous tics are basically what you want to avoid. I mean, yeah, don't have a pen. You're not going to be taking notes, you know?
Right. Exactly. Or like I'm currently, while we're doing this podcast, I'm playing with a hair tie in my hands. You know, I would never want to have like a hair tie.
Yeah, no, I'm actually like, you know, I'm kneading my hands in a knot. And these are the things you just want to pay attention to.
Yep.
You know, basically, like if you know that this is an issue, I think just putting your hands on the podium, you know, lightly resting them, and if you notice that you start moving them around a lot, just sort of like returning to that focus of like just put them down, don't move them around. But ultimately, I mean, this is a learning experience.
Exactly. And I think that's the biggest thing is that. Just try and keep a little bit of a sense of humor about it. Don't take it too seriously. It is a learning experience. Even if you go beyond Moot Court and do advocacy competitions at your school, or even join an advocacy or a negotiations team or something like that may even travel to competitions. The stakes may feel high, but this is all to learn your craft. And so each time you do these, you're going to better your craft. You're going to be better at it. You're not supposed to be as well seasoned as the attorneys who are arguing in front of the Supreme Court. You know,
right, and they're also always improving. And, you know, I think that's another takeaway is like afterwards, think about how things went. Like, did they go well? Did they go poorly? Like, are there things that you would change in the future? And not just for you. You know, you can watch your classmates. You can watch the other people. This is how you learn to be a better lawyer.
Yep. Oh, I forgot one thing to help manage nerves. It's one of yours and my favorites.
Oh, yeah?
The listening to the playlist.
Oh.
No, I don't know why I didn't think about that. But this is I know you and I used to do this before exams. And I think it can actually be a great thing to do, especially if you're one of those people who can pick up nerves from other people.
Yeah, just go put on your earphones, put on your playlist, your power playlist. Yep. And just zone out. At that point, 5 or 10 minutes before your Moot Court oral argument, you're not going to be like learning anything that's going to make a difference. The only thing that's going to make a difference is if you go in focused and you go in ready to go. And, you know, maybe it's a guided meditation for some people if you have really strong nerve issues. But, you know, for me, it's like, oh, I might just listen to like an upbeat song.
Yeah, because that can help you just not get distracted. I think the only time in all my years of performing that I ever got on stage and had things go horribly, terribly wrong was I was backstage goofing around with my friends instead of paying attention to what I had to do. And then I went out on stage and I totally forgot the words to a song that I had performed in public probably like 20 times.
Wow.
Yeah, because I was just I didn't have my head in the game.
Yeah, you weren't in the right headspace.
No, I was just messing around backstage, goofing off. And then it was like, oh, wait, what am I doing here? Oh,
yeah, where am I? Oh, I'm in front of an audience.
Oh, I'm in front of an audience. Oh, there are people. Oh, whoops. You know, so yeah, just doing whatever you need to do to get in your own headspace and try different things out. Because I think if you can figure out what works for you, then you can use it for exams. You can use it at work. You can use it for lots of different things. So
yeah, you're entering a high pressure profession. So these are the things to start thinking about now.
Yeah. All right. I just wanted to make sure we didn't forget that one because that's always a fun one. Maybe Definitely. We should blog about what is on our power playlist.
True.
I know.
Good idea.
All right.
I'll make a note.
We'll work on that. All right. With that, we are out of time. If you enjoyed this episode of the Law School Toolbox podcast, please take a second to leave a review and rating on iTunes. We'd really appreciate it. And be sure to subscribe so you don't miss anything. New episodes are usually released on Mondays. If you have any questions or comments, please don't hesitate to reach out to Alison and I. My email is lee@lawschooltoolbox.com or allison@lawschooltoolbox.com, or you can always contact us via our website contact form at lawschooltoolbox.com. Thanks for listening, and we'll talk soon.